Welcome back to Between Two FARS. I'm Warnke Miller here again with the amazing Robert Tepfer, and we have been talking about contract interpretation principles. It's very important that you watch the whole series because this is really a question of equities. You have to look at the totality of the circumstances and apply all of these different principles. But there are so many contract interpretation principles, we really had to break it up into a couple episodes. So today we're going to talk about a very important aspect of contract interpretation, and that is extrinsic evidence. Now, we don't default to extrinsic evidence, right, Bob? Where do we start?
Okay, you start, as we said, the principle of apparent purpose, and then we're reading the contract as a whole, and we're looking at the specific language, including the order of precedence clause. We're trying to resolve things. Is the ambiguity patent or latent? Why? Because that seems more genuine. That's what the parties shook hands on when they began the contract. And when you leave the four corners of the document and you're going to extrinsic evidence, it smacks more of creating an ambiguity and searching outside what was the meaning of the minds, which should be memorialized in the contract itself. And so that's why we're kind of sliding over to a little bit that some would argue that it's less of what was agreed to and more into the equity, okay? And the equity is that the extrinsic evidence will show this is what these words meant. This is how you've done business and you thought it was wonderful before, and perhaps the government accepted this type of performance before, and therefore it showed their meaning of the minds that way. It's much more mechanical, but what it's doing is it's outside the four corners of the document showing what the parties intended and what they shook hands on. That's why you don't start there. You kind of look there when you don't have anything else.
All right, so extrinsic evidence pulls in aspects that are not written into the contract to help you understand what is written in the contract?
Yes. Well, it's I wouldn't say it could show what's written in the contract, but what it's really trying to do is show what the intent was.
Okay, the intent. Okay. Tell me how the conduct of the parties could help us understand the intent of the parties and thus be used as a principle of contract interpretation.
Okay, let's say you had the work be performed for 9 months. In the first 3 months, the government accepted it to a certain standard, was well aware of what was going on, and then only takes issue midway in. Clearly, they acted consistent with the contractor's interpretation of specific language. Moving a little bit further away from that particular contract, let's say it's one of a series of contracts that the government and this particular contract has had, and contractors had, and the government has accepted the work on prior contracts with no problem with the same language. The conduct, theoretically serves as an interpretation because the government said it was wonderful work and accepted it. Now, all of a sudden, it takes issue with that work and it looks disingenuous. It doesn't make sense. Why was it okay before, but now it's not? It's a little bit more remote. Lawyers are always told, be careful when you take exception to the work in, a certain standard that the contractor has put out, and then the contractor starts doing it that way repetitively to generate evidence. Okay, but the reality is you're trying to find the intent because it's nowhere in the contract's four corners.
What happens if you know that the other party is interpreting the language differently than you interpret it?
You have the duty, and this is pure equity, to come forward and explain that, take issue with it. Doesn't matter either side, okay? The issue is you're really taking advantage of that misinterpretation, and you have the knowledge of their interpretation. That's the equity.
So silence is acquiescence if they're putting forth an interpretation you don't agree with?
Yes. You have a duty to come forward right away. Why? Because clearly they're expending funds. Clearly they're acting consistent with their thoughts, and you know it. And you can't stand back, let that happen, and then take issue.
All right. What about, and this gets into some sticky situations, but talk to us a little bit about the concepts we need to be aware of when they start bringing trade practice to the table.
Okay, I've tried to stress in each one of these meetings that we've had on between two FARs that you need to have not just the contracting officer with their MBA and the lawyer with the law degree putting these documents together, but you need to have the folks that are going to have to inspect and accept and know how it's to be done. Have them review, explain to them that trade usage, custom and practice, if they're not spelled out in the contract, which theoretically they could be, they may not control, so that they're not surprised later, because you always end up with the engineer saying, this is the way everybody should do it. Okay, well, guess what? You've now created an issue. At best, we may have to litigate. And maybe it won't even be controlling. But to the extent you can incorporate by reference certain standards regarding that trade practice, you can certainly eliminate a lot of headaches later on because you've made it part of the contract. It's now within the four corners. Everybody knows if they don't like it, they could raise it. If they think it's inconsistent or it's a patent ambiguity, they have a duty to raise it. And that really kind of, the standard as to what you're buying is critical, and that puts it right out on the table, as opposed to waiting till you get in the middle and finding out how this particular contractor does that kind of work.
As you can see, there's a lot of intricacies when you start bringing in extrinsic evidence into your contract interpretation issue. Now, there are a couple more contract interpretation principles that we want to speak with you about before we begin to talk about the holistic aspect of your contract interpretation and how you have to take the totality of the circumstances into consideration. So stay tuned for the next exciting adventure in Between Two FARs.